Good afternoon, everyone. My name is Michelle Storms. I'm the Executive Director of the ACLU of Washington, and I'm happy to welcome you to this CLE, Incorporating Race Equity into Civil Rights and Civil Liberties Litigation, Part 2. We're very happy to have your participation today in this incredibly important conversation. As the ACLU of Washington, we're hosting this series of CLE sessions because we know that we're far from racial equity in our society, and certainly we have not achieved it in our legal system and courts. If you were able to attend part 1 of this series, you heard Twyla Carter break down the history of our country and our laws with particular highlights on racial discrimination, inequity, everything ranging from slavery to Jim Crow to mass incarceration to redlining and on and on. Unfortunately, our country's history is tainted with racism. At the ACLU of Washington, we're concerned about the civil rights and civil liberties of all in Washington state. The issues we cover include everything from reproductive rights to protest rights, criminal legal system reform, immigration, policing, and so on. If there's a constitutional right, we have probably advocated to make it stronger, or we have fought against the violation of it. We do our work in the courts, before legislative bodies, and providing public education and activism tools. We're able to do our work because of many volunteers, community partners, and of course, cooperating attorneys who work on cases with us. Our panel today includes 3 wonderful cooperating attorneys and one of our staff attorneys, and they'll talk about how they've incorporated race equity into their work and why. They'll also likely make a pitch for why being a cooperating attorney is so rewarding. So here's who our panelists are. Salvador Mongia, a partner in Gordon, Thomas, and Honeywell firm. He goes by Sal, and he's been a cooperating attorney with the ACLU of Washington since 1986. He's represented incarcerated individuals in class action lawsuits involving Pierce County Jail, individuals incarcerated at the Northwest Detention Center, and other matters as a cooperating attorney. He's a frequent speaker on racial bias in the legal system at numerous CLEs, is a past president of the WSBA, and most importantly, he's just a good guy. Dan Shee is a partner at the law firm Sussman Godfrey. He formerly served on the legal committee and currently serves on the board of the ACLU of Washington. In addition to his commercial litigation practice, Dan has a substantial pro bono practice litigating social justice issues, including amicus cases dealing with LGBTQ equality, challenging presidential executive orders, and police accountability. Dan is a former president of the Q Law Association and currently chairs a joint committee of 11 minority bar associations working to make those elected to law enforcement positions like prosecuting attorneys more responsive to the concerns of minority communities. Lila Silverstein is an appellate public defender at the Washington Appellate Project, passionate about protecting the constitutional rights of individuals and ensuring equal access to justice for all. And an appellate public defender since 2006, Lila represents indigent clients in the Washington Supreme Court, all 3 divisions of the Washington Court of Appeals, and the United States Court of Appeals for the Ninth Circuit. Her most notable case is State v. Gregory, which we'll hear much more about today. And outside of casework, Lila also volunteers presenting CLEs, writing amicus briefs, serving on bar committees, and special to us is a recent recipient of the Kathleen Taylor Civil Libertarian Award from the ACLU of Washington, among many other recognitions. Last but totally not least, Nancy Tellner is a senior staff attorney with the ACLU of Washington. She has been an attorney with ACLU since 1995 and has worked for many years as a criminal defense lawyer, representing clients in state and federal courts of appeals, as well as in tribal court. Her work at the ACLU now includes a wide variety of civil liberties topics and many amicus briefs. We all know her at our office and in this community as pretty much a walking encyclopedia of civil rights and civil liberties case law and history, and she is a treasure in our office. So let's get right to the content. And as we proceed, what I want to ask of you who are participating in this CLE today, please be thinking about the questions you have for this esteemed group. We're leaving a healthy amount of time at the end so that you and the panelists can be in dialogue together, because we know that the more we talk about these issues together, the better advocates all of us will be for equity, racial equity in our courts. So the first part of our conversation is going to focus on some of the recent cases where we have raised issues of racial equity. And we'll talk primarily about 3 cases, and the ACLU showed up in all of these as amicus. But to begin with, I want to turn our attention to Nancy and ask Nancy to talk about what are these amicus cases that the ACLU Washington is engaging with? How do we pick them? What is the unique opportunity to make change in the law through amicus cases? And then how do we work with cooperating attorneys? So I know that's a lot, but I'll prompt you. So Nancy.
Well, thank you. And so happy to see everyone today. Welcome. So amicus curiae, which is the Latin phrase. And every time I say that, we always have a debate about how you actually pronounce it. And the answer is nobody knows. So you're free to use whichever version you want. But it means friend of the court. And so amicus cases are ones where the ACLU is not a party to the litigation, but where we think the case presents important issues and we have something to say that would, quote, assist the court. The word assist comes from the Washington Rule on Appellate Procedure. It's RAP 10.6. So whenever we file a motion in every case, we always explain how we think we're assisting the court. And most of the time they agree with us. Not always, but most of the time. Just also for reference, there's a federal rule on appellate procedure that also deals with amicus briefs. That's FRAP 29. And it refers to the motion to be amicus, where you have to say the reasons why an amicus brief is desirable. So there you go. It's assisting or desirable are sort of the key terms that we're looking for to satisfy the court rule. So we do have an active amicus practice. I don't have exact numbers, but it averages about 1 to 2 a month. Sometimes it feels like a lot more than that when there's several of them due at once. But it averages out to about 1 or 2 a month. We keep an eye on cases that are in the Washington appellate courts, especially. We especially watch cases that are in the Washington Supreme Court. We're looking for cases that involve, like Michelle said, important civil rights, civil liberties issues, and looking for cases especially that have an impact on race equity. That's definitely a high priority, but it's not limited to that. There's a lot of information on the Washington Court's website that I'm sure most of you are familiar with that really helps us see like what cases have been decided, what cases have been taken for review in the Washington Supreme Court. They have the court's issue statements, all the briefing. So we use that a lot to keep an eye on what cases we might want to be involved with. But second really important area that I want to make sure and emphasize is we hear from our colleagues, our fellow members of the bar. So any of you, if you have a case that you think might be of interest to the ACLU as an amicus case, please email us, call, whatever it is. We really would like to hear from you about your case and give us a chance to consider it. And attorneys do that all the time, all over the state. Definitely an important way for us to hear about cases. Another important aspect of what we do on our amicus cases when we decide to do them is we rarely do them alone, right? Like occasionally we do, but connecting with community, connecting with other professional organizations, sometimes legal organizations, other times general community organizations, sometimes law school faculty, sometimes law school students, and those are just a few examples. Like a part of this whole process is really reaching out as creatively and as comprehensively as we can to involve people in doing this work. So that's an important part of the aspect of it. Just examples of some of the kinds of topics we do. I think Michelle's listed some of them. Certainly there's a fair number of criminal and juvenile cases. We're looking especially for ones that give us a chance to fight back against mass incarceration and all the racial bias that goes with that. And sure enough, there have been a lot of those opportunities and will be more. So we're definitely interested in those. The criminal cases also can involve search and seizure, sentencing, right to counsel, free speech, Jury diversity has been another one that we'll talk about some more. Criminal related also includes prison condition cases. So we've definitely been involved and have an interest in that. Police practices and police misconduct, we'll talk about more. Definitely a strong interest in that. We don't always, very often do family law, but occasionally there are some custody cases that have involved LGBT rights, so take an interest in that. Cases where the state is trying to take custody of children, those are of interest. General discrimination law cases, general free speech cases, religion, reentry, immigration, voting rights, privacy. I could go on, but I won't. And then just as an example of right now, we get stuff that we're not used to dealing with. There's a case out of Spokane dealing with racially restrictive covenants on real estate property deeds. So certainly important race equity issues there. And that's one that we're likely going to get involved with in some fashion. So just wrapping up here, I just want to encourage all of you to join us for this exciting ride. There really are unique opportunities to work on these cases, to shape the direction the law is going in, to really have a huge impact, but with a project that's limited in time, right? Like it's a bunch of work to do a brief, even if it involves actually writing the brief. But once it's done, and then it's up to the parties in the court. So it's a good opportunity to have a lot of impact with not having to invest, a prolonged period of time. Let's put it that way. It's a great opportunity to work on issues you don't normally do in your practice. Really exciting issues, research things you may never have thought about, networking with others like we've talked about, and just the process, the thought process. It really is the brainstorming, thinking of some new legal theory that could have an amazing impact. That's the kind of stuff we're hoping you'll join us in participating in. Thanks.
Thanks so much, Nancy. And it's true, it is an exciting ride, but it's also like this incredible opportunity to bring a perspective before the court that might not be brought by one of the parties, so that we can try to move our law and our courts forward in a positive direction. So to that end, I think I'd like to now turn to Sal to talk about a case that you were involved in with us called Henderson versus Thompson, and would love for you to just start by telling us what was the case and how did you get involved?
Sure, Michelle. So this is a case that just on its face, you would think, why is the ACLU involved, right? Because it was, if you will, a simple motor vehicle accident, a rear ender, and liability wasn't contested. So the only question was damages for the jury. So just on those facts, you'd say, again, why is the ACLU involved? But once we got a little deeper in there, the plaintiff was Black, which when I'm saying that and I'm just preparing for the CLE, I was thinking, wow, I know there's going to be people out there saying, well, why would that raise any type of red flags just by that fact? This is 2021. And certainly, Sal, you're not saying that should immediately put people on notice or on the alarm. And that's just the opposite. And I think that's one of the reasons I got interested in this case. And one of the reasons the ACLU got interested in this case is because race plays such a huge factor in our legal system. Not only that, but the plaintiff was a woman. The plaintiff had Tourette's syndrome, so she had a disability as well. And the claim by the plaintiff was the jury process took into account my race because the amount that the jury awarded was so low that could be the only explanation for it. Now, I want to point out also that the plaintiff's attorney was a Black woman and that the defendant was a white woman. Not sure how much that would play in, and they didn't play up those aspects as much as the plaintiff's race. And as we delved a little bit more in the amicus brief, however, is her other characteristics as well. And that's something I'll talk about later. I know Michelle's going to ask me later about intersectionality, which is huge and so important for everybody to know about. But that is it's an overview. But if you want, Michelle, I can tell specifically what, again, I guess drew me into this case and a little further into this.
Well, certainly let us drill more deeply into it, right? Because you've pointed out that there were a couple of things going on, right? We had a Black woman plaintiff, a woman living with a disability, very low award. What was the process in which you all decided what arguments you wanted to make? What were the arguments you made? And how did that all go forward?
And that's one thing about being an amicus. We don't represent the plaintiff. We are truly a friend of the court and trying to explain maybe a certain aspect of the appeal that otherwise would not get fully fleshed out, analyzed, and made sure that the court consider all aspects. And more, if you will, from a neutral standpoint almost, we're not interested in a sense, whether the plaintiff prevails or not. We're interested in whether justice prevails. And so there were a number of arguments that the plaintiff made on appeal, raised on appeal, that we certainly did not join in. She was alleging errors that the trial court made as far as rulings about keeping evidence out or evidentiary rulings. But what we were interested in is this particular situation dealing with her request to have a new trial. So post-trial, she had an attorney argue. So she had two main trial attorneys, and then post-trial also brought in a third attorney. And Mr. Steve Fury was one of her post-trial attorneys. And he raised up the argument to the trial court. Look, at your honor, it looks like the jury process was tainted because of race. And here, not only was the low verdict a sign of that, but also the fact that after they deliberated and rendered their verdict, they asked this court, your honor, to make sure that the plaintiff was outside the courtroom before they would leave the jury room. And before he could actually continue with that argument, which is kind of interesting in the way that this handled and why we got involved here, because it raises so many issues, is that the judge said, no, Mr. Fury, I guess I should correct the record. You know, that's the reason I dismissed the plaintiff, Ms. Henderson, from the courtroom is because I always do that in all jury trials. So it's my standard practice. So I just want to let you know that. After that argument was made, Mr. Fury, I mean, these are all declarations that are sworn under oath. He said, you know, my recollection, you talked to the jury, you came back and you said the jury wants to have, and I'm paraphrasing a little bit, to ensure that the plaintiff is out of the courtroom, and you did that. Now that Ms. Sargent, again, one of her trial attorneys and another trial attorney submitted affidavits, as did Ms. Henderson, the plaintiff herself. And the judge still did not do anything. Now, as I talk along, as I get a little further down my argument, what the trial court is required to do, if there's a prima facie showing by a party that in fact the jury process, and I'm just using my words, infected by race or ethnicity, then the trial court must hold an evidentiary hearing to determine whether in fact that in fact happened. The trial court did not do anything other than say, no, this is the reason I did it, and rejected those arguments. That's why we're up on appeal right now. So what Michelle really raises is just so many issues. One is, as this court, as our court has recognized, you know, there's explicit bias and there's implicit bias. And that's one thing that still people aren't getting really, it's a hard concept to grasp because it means you don't know, right? It's unconscious. The trial court would not know whether she's biased herself, and yet she's just making this flat statement. That's not the reason I made sure that Ms. Henderson was outside of the courtroom before I let the jury out of the jury room. The trial court just has a blind eye to that. And I think that's one thing we pointed out to the appellate court, the state Supreme Court on that is, you know, this is one reason why you have to have such a low bar to having this evidentiary hearing because of implicit bias. The other thing about this is that we looked at the record, and that's a great thing about the amicus position, is that you not only can argue what's in the record, which of course that's what, as a party, you are limited to. The appellant is limited to what is in the record. We can go to materials outside the record. So we cite obviously social studies, the research in this area, but we can also bring in other materials. So one thing we did was, well, let's look at how long this particular judge had been on the bench, because she said it's a matter of course. It could be hard to prove that one way or the other, but we think the appellate court should know that. So we asked the clerk's office, what is the history of this judge? How many trials, jury trials has she had? Well, found out she just joined the bench 5 months before this trial. So it's not exactly like she had a long track history of jury trials. Not only that, but we checked the records, and during those 5 months, she had 2 jury trials. So to make the statement, that is my standard practice when you are having litigants saying, we heard you, Your Honor, saying that you are having Ms. Henderson leave the courtroom because of the concerns by the jurors, should have raised a red flag even to that judge herself. But again, implicit bias is so hard because you can't recognize your own biases by definition. Not only that, but we pointed out in the record that the defense attorney, now you would think that the defense attorney who wants to win and wants to make sure that that jury verdict stays intact is going to be supporting the trial judge. So if the trial judge, in fact, didn't say the statements, you would point that out as a defense attorney. In other words, if I was a defense attorney and the trial judge never said, I am excusing Ms. Henderson because of the jury's request, I would put in a declaration. Defense attorney didn't do that. They stayed silent on this. We pointed that out to the court as well. And I know this is going to delve into a little intersectionality, but I can't help it, Michelle. I'm going to just kind of give some background as to why I got involved and why I think the legal team and why we focused on these particular issues. Anybody who's aware of the social studies knows that as in the civil, which I practice in the civil arena, and I do a lot of personal injury work, a Black plaintiff is going to be awarded less for pain and suffering than a white plaintiff. There was a very interesting study done in 2015 by the Oregon Law School out of Multnomah County, which is where Portland is, looking at the history of lawsuits involving civil litigants. And I'm giving you the short version. But what it determined was when it came to, if you will, hard damages, economic loss, juries awarded both Black and white, I'm just using those terms kind of an oversimplification, the same amount. So if you have lost wages, medical bills, there's not any variations. Jurors pretty much stuck to that. But when it came to pain and suffering, for very similar injuries, which the study factored in and did their analysis, they found that the jurors in Multnomah County, so again, Portland, a very progressive area, awarded Black plaintiffs 40 cents on the dollar of what they awarded white plaintiffs. Now, if you're not aware of that, a verdict like this, you say, okay, so she didn't get as much as she asked for. So she got a very low verdict. It happens. It starts raising flags. And if a judge doesn't know this, and again, a judge is unaware whether in fact this is tainted by racial factors. In addition, we have the fact that, again, historically and still, healthcare providers and people in general think that African-American people have a higher pain tolerance. And, the stories go back historically, they're horrific. And I'm not going to go into that now because I don't have enough time. But we know that as well, that that's going to be part of the process. We know that people have biases against people who are disabled and who are neurological divergent, such as Ms. Henderson. So all of these things came into play, and we're wondering, why did the trial court do what it did here? Michelle, do you want me to get to the legal part now? Do you want to save that part? But I'm setting it up, why we got involved and what we're looking at and deciding what to, in fact, analyze here.
Well, I think, yeah, so first of all, so much great information you shared already, and it's hard to hear, but it's important to hear because not everybody realizes what's going on. Not everybody has seen the social science research. Not everybody understands about implicit bias and the experiences of Black people and other people of color in the court system. So it's really important what you've pointed out. Why don't you take just a few minutes to talk about what the legal arguments are, and then we'll go on and talk about one of the other cases.
Okay, so make sure I'm not taking up too much of my time here. So the legal crux of this was a case already decided by the state Supreme Court known as State versus Bear, B-E-R-H-E. You're all given links to all the materials and you'll find all the sites and materials there. But briefly, that was a criminal matter. Juror number 6 was the only Black juror. The jury convicted. The trial court did what trial judges do at the end. They poll the juries. Is this the verdict of the jury? Is this your verdict? Asked all the jurors. Juror number 6 said yes. However, the very next day, she told the defense attorney, you know what, I felt pressured during this process as because of who I am and the way that I was treated. Well, the prosecution submitted declarations from the other juries saying, no, race did not play a factor into this thing. The trial judge did not hold an evidentiary hearing to determine whether or not racial bias played a factor into the jury's deliberation. Court of Appeals upheld the denial of a new trial. State Supreme Court said no. There should have been an evidentiary hearing by the trial court. And what was great about Barrett, our state Supreme Court followed the process of General Rule 37, which again, you heard Nancy mention during her talk, and we may talk more about it later. But it is a very low standard as far as trying to minimize making sure that people aren't excluded from serving on jurors because of their race or ethnicity through the use of peremptory challenges. And they say minimizing because it's always going to happen. And I don't think it's ever going to eliminate, but it will minimize that process. And said that same standard applies here, trial court. There was a prima facie case made out. You were obligated to hold an evidentiary hearing to look behind the allegations to determine whether or not racial bias was a factor here. So we're arguing to the state Supreme Court here the same thing, making it clear, one, Barrett applies to civil cases as well as criminal cases, because again, the defense is saying, no, it only applies to criminal cases. No, the analysis doesn't make any sense, just applying it to criminal cases. Two, it should have been done here, and it would have been a very easy process. For one thing, the trial court should have simply asked the bailiff, the judicial assistant, who was the one who was there, what was their recollection, should have put the defense and asked them, what was your recollection of what happened? That by itself, I think even with the information, the declarations submitted, there was prima facie showing in order to require this evidentiary hearing. However, the trial court could have also called back the jurors themselves to make sure that, what was the reason? Did you ask that Ms. Henderson leave the courtroom first before you would even leave the jury room? And if so, why? I mean, is it because you were scared of her? Because and again, I'll talk about this a little bit more in intersectionality, but we all know the trope of angry Black woman. Were you so, scared that you couldn't even walk out by her? So all of these things should have been done by the trial court. So that's the basic framework that we set out, and we made it very clear to the court that needs to be an extremely low bar. Again, could an objective observer looking at what happened in this case with the jury, could an objective observer conclude that race was a factor, not a determinant factor, but a factor as to the jury process? That is the standard that we are arguing to the state Supreme Court. Okay, Michelle, I think this kind of gives you the overview of what went into this, and we could talk more about intersectionality and some other
Absolutely. And that's so excellent. And I just have to say thank you so much for doing that case and for advancing those arguments. So incredibly important, just so important. So yes, Sal, we'll come back to you some more later. But now, just on this idea of how not everybody gets treated the same way in cases, and unfortunately, we find that falling on racial lines quite a lot. I want to turn to Lila to talk about State versus Gregory, because this really was about in death penalty cases that Black people and white people are not treated the same. So I'd love for you, Lila. I know in this case, you actually were representing the client, so you weren't doing the amicus brief in this one, but if you could just talk about what that case was and how it was proceeding, we'll start there and then we'll get into some more nitty gritty as you go on.
Sure, Michelle, and thanks for having all of us. Just to, cut to the punchline first, Gregory was the case that ended the death penalty in Washington state. The Supreme Court agreed with our arguments that the death penalty violated the cruel punishment clause of the Washington state constitution because the death penalty was imposed in an arbitrary and racially biased manner. So yeah, race equity played a critical role in the Gregory case. I mean, race equity plays a role in many of my cases, if not most of them, because I'm an appellate public defender and the criminal legal system is infected with racism and racial bias. But it is especially critical in certain cases, and Gregory was one of them. I was appointed on that case in December of 2012, along with my wonderful co-counsel, Neil Fox. And as you might remember, the Supreme Court decided the case in October of 2018. So we went through 6 years of really intense litigation before the court decided the case. But the very first thing I did after the Supreme Court appointed us in 2012 was to commission a statistical study on the impact of race on the imposition of the death penalty in Washington. And I did that because Justice Charlie Wiggins, who is now retired, but who was on the Supreme Court back then, had just written a dissent in the previous death penalty case indicating he thought there might be a problem with racial disparity in the imposition of the death penalty. Many people had long argued that the death penalty in Washington seemed to be imposed randomly and arbitrarily. In other words, there were just a few people on Washington's death row for aggravated murder, but many people who unfortunately committed equally heinous aggravated murders were serving life sentences. And there seemed to be no rhyme or reason to who was on death row and who was not. There was no meaningful difference between this group of defendants and the broader group of defendants serving life sentences. And people had argued that this problem constituted a violation of the Eighth Amendment and violated a statute we had in Washington that required proportionality in capital sentencing. But our Supreme Court had always rejected these arguments, including in that last death penalty, case before Gregory in 2012, which was State versus Davis. In that case, the court again rejected these arguments. And again, only a few dissenters voiced opposition. That's the way it had been for years, for decades. But these dissents were really important. There were 3 dissenters in Davis. Justice Fairhurst wrote the principal dissent saying she would have reversed that death sentence because it was arbitrary and disproportionate in light of the sentences everyone else was receiving. She said, you may as well flip a coin to determine who gets the death penalty in Washington. That's how arbitrary it is. Well, Justices Stevens and Wiggins joined Justice Fairhurst's dissent. But as I mentioned, Justice Wiggins wrote his own dissent, and he did something that was pretty unusual for the court at that time. Remember, this was 2012. Justice Wiggins, on his own, raised the issue of potential racial bias in the imposition of the death penalty. The parties hadn't raised it, and the amici hadn't raised it. Actually, Nancy Tellner and I wrote the amicus brief in Davis, one of the amicus briefs, and we didn't raise the issue of race in that case. There were other good issues that we focused on. Remember, this was the era when 2 members of the court were saying that the reason there are more Black people in prison is because Black people commit more crimes. So there was that, and there were other strategic reasons that we weren't focusing on race at that point. But Justice Wiggins did. Justice Wiggins reviewed the official data set that we keep on aggravated murder cases, and he observed that over 60% of the Black defendants for whom prosecutors sought the death penalty were in fact sentenced to death by juries, but only 40% of the white defendants for whom the prosecutors sought death were in fact sentenced to death by juries. And he didn't know if this difference could be explained by valid case characteristics. For instance, if all of the Black defendants had murdered multiple people and all of the white defendants had each murdered just one person, maybe that could explain it rather than race, right? And there are all sorts of other valid characteristics you're supposed to take into account, that juries are supposed to take into account when determining a sentence. And Justice Wiggins did not have the capacity to control for all of those variables and isolate the race variable. And he also didn't know if this disparity, huge disparity he observed, was statistically significant. So what he said in his Davis dissent is that he would have remanded to the trial court to take evidence on these statistical issues. But the majority was very offended by this suggestion of racism and dismissed it out of hand because, again, that was the era we were in. A huge swath of the legal profession was still in denial about systemic racism. The tide was just turning right around that time. But Justice Wiggins's dissent was out there. And of course, when a justice writes a dissent like that, what they are really doing is sending a message to judges and attorneys about what should happen in the future. So this is an important lesson. It's really important to read dissenting opinions and concurring opinions of cases when they come out. Everybody notices them for the US Supreme Court. It's really important if you're a practitioner, a state court practitioner, to do the same thing with your state Supreme Court cases, because it is in these dissenting and concurring opinions that justices will send messages about what should happen. And Justice Wiggins did this. Justice Wiggins was really a hero in this regard. He did this in the context of racism and the death penalty, and he did this in the context of racism and jury selection, which hopefully we will have time to talk about today also. In any event, I had just read this Davis opinion, including Justice Wiggins's dissent, in September, I think it was, of 2012. And then the Supreme Court appointed us on Gregory in December. And that's why I knew I had to commission this statistical study on race and the death penalty in Washington, so that a social scientist could do what Justice Wiggins couldn't do and what we as lawyers can't do. So I contacted Dr. Catherine Beckett, who the ACLU is very familiar with at the University of Washington, and she recruited Dr. Heather Evans to join the team. And they performed a multivariate regression analysis. First of all, we gave them the data, this data set that Justice Wiggins had reviewed. And then our researchers performed a multivariate regression analysis to determine the impact of race on the imposition of the death penalty by controlling for all of those variables that are supposed to be relevant. And so Neil and I worked with Catherine and Heather very intensely for the next several years, because doing these studies requires both a great deal of statistical expertise and a great deal of legal expertise. And that's something you do need to be ready for if you're going to commission a new study. Thankfully, there's tons of existing studies out there and you won't usually have to do that. But if you do, please be aware, this is not the kind of thing that you can just hand over to an expert and expect a report back in a few months. You have to work on it with them, and it's extremely labor intensive, but it's worth it, right? In any event, ultimately, as you know, if you've read the opinion, Doctors Beckett and Evans concluded that in Washington, Black defendants were more than 4 times as likely to be sentenced to death by juries as white defendants after controlling for those case characteristics that were supposed to matter. And that's obviously very troubling. So we made multiple legal arguments based on this study, or in part on this study, including the one that ultimately prevailed. And we also got lots of wonderful amicus support, including from the ACLU. National ACLU attorneys Jeff Robinson and Cassie Stubbs did tons of work. Washington ACLU attorneys Nancy Tellner and Jamie Hawk did tons of work, and cooperating attorneys from the Orrick law firm did tons of work. So it's really important to volunteer as a cooperating attorney so that you can help on these cases. And it was really important for the ACLU to take on certain roles because we couldn't do it all. It was really important for us to do 2 things. First of all, we had to design and execute a reliable statistical study and then prove its reliability during years of so-called special proceedings that the Supreme Court instituted. So we had to handle that piece. And then the second thing we had to do was, of course, tie the results of the study to the legal arguments under the 8th Amendment and the state constitution and the statute. And if you want to see how we did those 2 things, you can look at the document titled Appellant Supplemental Brief. That's one of the links in your materials. But the ACLU added value in a couple of important ways. First of all, they connected the results of our study to the history of slavery and Jim Crow lynching and drew that line from the beginning of our country to the results of our study, and showed that it was inevitable and indeed purposeful, and that the court needed to do something about it, right? And another critical thing the ACLU did, as Nancy alluded to, is to recruit others to join them. So the ACLU attorneys recruited 52 or maybe even more retired judges to sign off on the brief. And then also the ACLU recruited social scientists from around the country to file a separate brief endorsing the methodology and conclusion of our study, which I think was really critical, right? Because this was a study that was commissioned by one of the parties. And even though social scientists would, of course, never do anything unethical and risk their professional standing by being partisan, the fact of the matter was this was a study commissioned by one side. So it was really helpful to have all of these other social scientists endorsing our study. And so it really did take a village to achieve this result. And of course, by the time the case was heard and decided, thankfully there had been quite a bit of turnover on the court, such that Justice Wiggins was no longer the lone voice talking about racial bias. Several members of the court were passionate about addressing racism and receptive to these arguments. So a lot of different things came together and had to come together for the right thing to happen. I think that's about it, Michelle.
You know what? That was such a wonderful way of telling the story, all the way from the beginning, the facts that happened, the nugget and tidbit of watch those dissents and concurrent opinions, and really also not only just talking about what you did and what legal arguments were made, but putting it in the context of some history in terms of who was on the court, in terms of things that were happening in the country, and even in terms of our growing understanding of the ways in which racism shows up across our systems, which is still an evolving understanding, right, for all of us in this country and in society. And even those of us who are right here now, we're still learning. I'm still learning and really grasping what's going on. And so, so appreciative of your work on that case. And we will come back to say more about it later, but I want to get to our third case that we want to talk about today that Dan worked on, which was about the Inquest system, and this was the family of Demarius Butts versus Dow Constantine. And so Dan, I'm curious, how did you get involved in that case, and what was that case about?
Well, the case dealt with King County's procedures for inquests, which are used to investigate the causes and circumstances of certain deaths. Each of the 3 inquests at issue in the case concerned the police-involved killing of a Black community member, Demarius Butts, Charlena Lyles, and Isaiah Obed. The case was before the Washington Supreme Court on direct appeal of a Superior Court order. Ruling on a challenge by the police officers, the Superior Court had invalidated and enjoined King County's recently reformed inquest procedure. Now, among those enjoined reforms were things such as allowing discovery or hearing from expert witnesses from outside the police department and inquiring into law enforcement policies and training and whether those may have contributed to the death. The inquest reforms had been enacted in response to community concerns about a lack of thoroughness and fairness in inquest proceedings. Until then, inquests into police-involved deaths seemed geared toward exonerating officers without shining light on what happened, let alone providing accountability or suggesting ways to prevent future deaths from occurring. So the procedural reforms were intended to address that, but the Superior Court struck them. And so we got involved because the ACLU of Washington asked me and my law partner, Edgar Sargent, at the Sussman Godfrey firm to take on an amicus brief. The amici were to be a coalition, which was only partially formed at the time, but a coalition of community groups seeking an end to what they viewed as state-sanctioned police violence against Black individuals. And we were excited to take that on and to give voice to the concerns of community groups on an issue that we in the firm cared deeply about.
Thank you so much, Dan. So can you say a little bit more about then what happened when it was time to pull that brief together, and how did you go about forming the legal arguments that you formed, and how did you circle back to your, I guess, clients or the amici, right, to see, to sort of check that you were headed in the right direction? How did it all just really unfold?
Well, the race equity was kind of a driving theme of the brief because of what the amici were. But it turned out our arguments went beyond that, and let me explain that a bit. After leading with a lengthy race equity discussion in our brief, we made other substantive points, including that inquests had a long history of revealing shortcomings in regulations, policies, and practices. They've actually been used to investigate all manner of unnatural deaths, not just police-involved deaths, and to shine light on their underlying causes. That involved a good deal of historical research, mostly by my colleague Edgar, into news reports from the late 1800s, early 1900s, about inquests following building fires and streetcar accidents. And that history showed that inquests were not merely about confirming a medical cause of death, say smoke from a fire or being thrown from a streetcar, but rather they looked at the underlying causes, such as inadequate training, conflicting regulations, and whatnot, and actually suggested improvements to future deaths. So that confirmed that inquests have long involved robust inquiries into relevant circumstances. Now, that history could have all been laid out without any reference to race equity. But we were giving voice to this coalition of community organizations. And it was important to discuss race equity as the shared demand of those organizations. And so our message to the court wasn't just the substantive points in the brief. Another message was who was in the coalition making these points. And they were groups advocating for police reform or advocating for Black communities. But we also brought in groups serving other racial minorities, or advocating for disability rights or equality for LGBTQ persons, faith organizations, Washington women lawyers. So this was a broad group, and the thing holding it together was their interest in the race equity component of this case. And that was sort of the vehicle that let us make additional arguments. But each of these organizations had their own reasons drawing from their own organizations and mission statements for joining the coalition. And one example really sticks in my head. It was from a Jewish organization, which asked us to include the following in our explanation to the court in our motion to participate as amicus. They asked us to include this language about why they had an interest in the case. And I'm quoting, all Jews know what unaccountable state violence can do, especially when the impact is felt by specific groups, and we say never again. As that example reflects, it was really important to emphasize race equity as the key message of the brief. And that it was the shared concern that brought together a wide spectrum of community organizations to make other substantive arguments that weren't necessarily expressly tied to race. So we actually had like a lot of latitude about what legal arguments, substantive arguments to make, because the community organizations mainly wanted to express their perspective, their sadness, their outrage about the killings of Black people. And we wanted to tie that into other analysis that the court would find persuasive, but since the client organizations generally have a history of advocacy or expertise on inquest procedures, they left that to us. And of course, we made those decisions about what to include and such in consultation with the ACLU of Washington, which had more experience and connection to issues of procedural fairness, maybe not inquests, but at least procedural fairness type questions than some of the other amici. So now I'm going to shout out Nancy and Tony Davis, were great partners in that work.
That's so great, Dan. And I'm not going to lie, as you sort of talked about the comments of the Jewish organization and the reasons why so many people got involved, it really gave me goosebumps, right? And yet we're talking about this thing called inquests that most people don't even know what they really are. And thanks for explaining it. But also it's this thing that's been around for a long time. So when we think about our systems that have been in place, that have been, that are just deeply embedded with a lack of equity. I mean, that's definitely one of them. And Nancy, I know I didn't prepare you ahead, but I just know you have a lot of feelings about inquests. And, and maybe you could just say a little bit more about what it is, big picture, that we were trying to accomplish in taking on a case like this, as far from the ACLU perspective, because this is something that we've been thinking about in our organization for a very long time.
Certainly, and just confirming, it's been a very long time. So one of the first things I did when I started working at the ACLU of Washington was go observe an inquest, a King County inquest. And it was appalling. I mean, it was, Dan alluded to the history. I mean, so it was another police shooting of a Black man. The community was outraged. There didn't appear to be any reason why this person lost their life at the hands of the police. So we attended the inquest, and and I sat in the courtroom with all these uniformed officers, and it was obvious the effect that would have on the jury, and then watched, the family, I don't remember if they had an attorney or not, but it wasn't accepted that they did at the time. And then watched the prosecutor who worked with the police all the time, sort of ask friendly questions instead of really getting to the reason of what happened, let alone bringing out the lack of justification. And then that was yet another case where the outcome was exactly what it was in all these other cases, that the police actions were found to be justified. So that's why I had a particular interest in seeing the inquest procedures improved. And then this case, that was about exactly that, was a huge opportunity to make those points. And then I can't emphasize enough the importance of the work Dan and Edgar did. The historical research, they had to figure out a special procedure for giving the court those newspaper articles, finding them in the first place, newspaper articles from the 1800s, and then getting them to the court so they could see exactly what they said. But just, what a difference that makes of having done that research and that work, and then explaining why it was highly relevant to the legal issues before the court and why it was supportive of the parties' arguments. And they did all that, you know, and then we got the ruling just a few weeks ago, where the court, you know, unanimously ruled in favor of the families, you know, and supporting exactly the arguments that the amicus brief had made. And, you know, I don't remember, I don't think they specifically referred to it or cited it, but it was very clear, many parts of that ruling, the influence the amicus brief had. So that's what we mean by impact on a really important issue. I mean, that, you know, the briefing and then the ruling changed decades of the way the law was furthering racial bias.
So I just find myself having huge gratitude to Dan and Edgar and to all of you for taking on the issues and making the arguments you make. And thank you, Nancy, for just talking about what it felt like to actually sit in one of those. And then imagine being the family member sitting in one of those with all the uniformed officers and, you know, the prosecutor asking friendly questions and all of that. So this work does have huge impact. And so we're going to come back to that. We're going to come back to the conversation with Dan about what it's like working with a lot of community organizations versus, you know, a lot of the work we have. You know, we have some lawyers and judges sign on, but this was really different. So we'll come back to that. And I'm going to now step back a little bit and have a little bit of a larger conversation about why we're doing this. And all of you in describing the cases that you worked on and where the lack of equity was just so shocking, frankly, and yet just a basic part of our legal system and our practices, right? You've already answered the question why we talk about race, but let's dig in a little deeper on that. So in that first CLE, as I referenced before, Twyla Carter really set this framework of the history of racism in America and how so much of that is embedded into actual laws that have been enacted, into cases that have been decided, and that, so now each of you as a lawyer, as an advocate, has decided to take on this cause, right, and get engaged with it. So Sal, as promised, let's come back and talk about why we spotlight race, and particularly as you began to reference before, but we knew we were saving it for later, talking more about intersectionality and why is that important, and you can talk about it in the context of the Henderson case or however you want to talk about it.
Okay, so not too long ago, when I'm referring to a legal system, I quit calling it the justice system, because I don't think that we have a justice system. We have a legal system. And I'm very serious about that, because as I think Lila, and I love the term she used, it's infected by race. Race infects our legal system. And I agree with that viewpoint wholeheartedly. Primarily because race infects our whole society. And I think that's where we start the discussion. I mean, people really have to be aware that this country was, well, pre-country, right, before the country was formed, was based on slavery, was based on racism. And what is a hard concept for people to think about now is that it still infects our country, because it's so antithesis to the way that we think or we want to view ourselves. But you know, and when I talk about, I just use very simple examples. I mean, and the social studies are out there. If you want to sell, it's an old example, if you want to sell an iPod, don't have a black hand holding it, because if a black hand on your little screenshot shows it, you're gonna have a less of a chance of selling that iPod than a white hand. If you're going to call your college professor and your name is, I don't know, Jamal Washington, you better come up with a different name, because you know what? College professors are less likely to call you back if you have, if you will, a black sounding name than a white sounding name. Better use Jim Olson, because you're going to get a call back. State legislatures, the same way. You know, I mean, I could go on and on about law firms, the way that associates are reviewed. Again, a huge bias against African-American associates, huge bias against women associates. And when they start doing blind reviews, it is amazing about how that changes. So when we say that, Michelle, you're saying, you know, we're addressing it in the legal system, that's correct. only because it affects all of society. And it should come as no surprise to anyone that it affects our legal system. It should come as no surprise that I have biases that I'm unaware of, that judges have biases that they are unaware of, that jurors have biases that they are unaware of. I tell you, I'm done. It's just kind of a side, whenever I do jury selection, it drives me crazy when somebody asks a juror, well, can you set aside your biases? Can you be fair? Of course they're going to say that because one, they want to believe they can. Two, they don't know about their biases. They really don't. And if you, as an attorney representing people of color, which I do, you better be darn aware of what those biases are and start having those discussions both in your trial brief with the trial judge and during jury selection. Because if you don't, then you are not minimizing, that's all you can do, minimizing the effect of that. Okay, sorry about that. I just had to kind of set the stage because now we come to the next big problem, is intersectionality, which is not really recognized a lot yet. If you look at the cases and the studies, it's coming along now more. And I apologize. I thought, oh man, I should do this. And I ordered this, unfortunately, one day too late on Amazon. I thought I was going to get it yesterday, but it's going to come sometime this afternoon. But the scales of justice. And, I was going to do white plaintiff, white defendant. Scales are even on both sides. But then we changed that to black defendant and have the scale go down. So just imagine that I got this done in time. Black woman goes down even further, has a disability, goes down even further. But what is interesting is, and I don't think the social studies have fully fleshed this out yet, this is just my gut, that these aren't simply additive, but somehow they're compounding. In other words, we know that there's a bias against African Americans. We know there's a bias against women. But when you combine those two, it's not simply 1 + 1, but you get 1 + 1 = 4 or 5 because of the biases and the tropes within this country about angry Black women. And people, again, you don't even know you have that bias. For anybody who hasn't done this, you should take the IAT test. IAT test, implicit association test. I've done it a couple of times, and here I am, Mr. Liberal, Mr. ACLU, cooperating attorney, former board member, you name it. And the first time I took it and I got creamed on, I have a bias against African Americans. And, I give these talks, and it's been a number of years. I remember one time before I was going to give another talk. I said, well, I'm going to take this test again, because I bet you I've improved. And what it is just for those who have not taken it, and it's validated because literally millions of people have taken this test. You were given 2 words such as health, illness, light, darkness, good, bad. In the first part of the test, you're supposed to put white to the positive word, black to the negative word, and do this as quickly as you can. Okay, no cheating, just do this as quickly as you can. Second part of the test, they flip it around, right? Now you're putting the word black to anything that's positive and the word white to anything that's negative. Should be able to do it the same amount of time, right? I mean, it's just, unless you have a bias. And you can do this bias against with disabilities, with gender, sexual orientation, you name it, they've got it and you can figure it out. Second time I took it, and I'm really trying hard, that bias is still there. Let me tell you, when I grew up, my mom was Japanese, my dad, who was Mexican, had this huge bias. I mean, they shoot against Black people. I mean, the prejudice they held is what I grew up with. And I will tell you this with all just embarrassment. I mean, those seeds are so deep in me that they continue to sprout. I have to do my best to try to weed those out. And they're going to be in me, I think, my whole life, no matter how hard I try. Look, I think my kids hopefully have less of those seeds because of the way they're brought up. And hopefully my grandson will even have less. But you've got to recognize that. And I always just love telling this story. Michelle, I hope it's okay if I tell this story. I'm going to take a minute here. Jesse Jackson, we all know who Jesse Jackson is. Telling the story about one day he's walking down the streets of Chicago, one evening, and he's walking down, and suddenly he hears a bunch of footsteps, and he gets a little worried, and they're coming faster and faster, and they're running. And finally he gets so scared, he looks behind him and he goes, "Oh, good, just a bunch of white guys." And he says, "Look, that was my viewpoint, just a bunch," and I felt okay. Now, Jesse Jackson can admit to that. Certainly you and I have to take a hard look inside of ourselves, because this is a guy who's given his life, right, the civil rights. So let me talk about intersectionality a little bit. So we've got the addition. Let me talk a little about Tourette syndrome. So it's a form of neurodiversity. So you have ADHD, OCD, autism, all fall within that class. And what the social studies have found, and what you've got to be aware of both as an attorney, as a judge, or really any member of society, is how people view people with neurodivergence. And how generally people view them as they're lazy, they're rude, they're awkward, they're unpredictable, and they're frightening. And let me tell you, this is exactly what Miss Henderson was facing with that jury. I mean, without a doubt. And that was the testimony, because she is awkward. She is, her behavior can come across as rude if you don't know that, in fact, she has Tourette syndrome. And even if you know that, it's that implicitness within you which isn't recognizing that that is how you are viewing her. So imagine that now you are in the jury. You have a plaintiff who is a Black woman complaining that she has suffered injuries as a result of being rear-ended in a motor vehicle accident. And the other side is saying she was not hurt that badly. Now, maybe she wasn't hurt that badly, right? I mean, that could be part of reality. Another part of reality is she could be hurt badly. And the way that you view the world, though, is through such a lens that you are discounting that harm. And if I make that proposition to you, am I out in left field? Or does the social studies, in fact, show that? Does the social studies show that, again, and I can just point you to a whole bunch of them, if you're a doctor, you are less likely to give the same health options as to a Black patient as you would a white patient. That is so well documented. And, how do you think the jurors are doing in that jury box when you have someone with, again, all these crossroads and all coming up to one intersection, and the jurors don't even know what's going on? Now, so when there is an allegation, when there is an assertion by a party to a trial judge, look at Your Honor, there is some evidence here that this verdict is the subject of racial influence, and we want you to look into this. Again, I think the ACLU position, which follows my position, the bar has to be low. We want this to be a justice system. We don't want this to be a system where you are already dinged. You are already starting this race, this foot race, if you will, where they found 5-pound bag on your right foot 100 yards back from your white competitor. Everybody would say that's not fair. We want one where, there's no guarantee you're ever going to win in litigation, but at least give people the equal chance. And we, as members of this legal system, have that duty to do everything we can to make sure that everybody has that relatively fair and equal chance. So I'll stop right there as far as intersectionality and why we're doing this work. And later on, if you want me to chime in about GR37, that Nancy and Lila and I were worked with 3 others on, and others than that as well. I'm happy to chime in as well.
Well, it's funny you mentioned that, Sal, because actually that's where I was going to go next. But first, I just want to say that I really appreciate that you mentioned the role that implicit bias plays in this. And also, I think really the key word that you stated around intersectionality is that it's a compounding factor. It's not a 1 + 1, right? It's more like a 2 × 10. Okay, mathematicians, leave me alone. Okay, so you mentioned GR 37, and I think I'll go to Lila first on this, but we've been talking about the ways that you all have engaged with cases before appellate courts. But it's not just the cases, right? It's also the rules. So whole other area of how the system operates is what the rules are that we follow. And what were those rules? Who wrote those rules? What viewpoint did they have on the system that was underlying that? So Lila, why don't you start and talk about some of the advocacy around GR 37, what that rule is, if folks don't know, and what the advocacy has been about.
Sure, Michelle, thank you. Well, GR 37, I have to admit, arose out of a case I lost in our state Supreme Court. So sometimes, well, most of the time, all of the time, you have to go through defeat before you can achieve some measure of justice. And I agree, we shouldn't really use the word justice to describe our system, but you can improve things so that there is a greater level of justice, but you lose a lot first. And I lost the case that started us down the track for developing General Rule 37. That was a 2013 case called State versus St. Cali. And in that case, I argued that my client's right to equal protection under the 14th Amendment was violated when the prosecutor exercised a peremptory challenge against the only Black prospective juror. The prosecutor had given reasons for her exclusion that I believed I proved were invalid under the totality of circumstances. In other words, I thought that we demonstrated that this prosecutor was actually excusing this juror based on race. And I told our Supreme Court that we hadn't been handling these cases correctly in Washington, that we had not applied the case of Batson versus Kentucky correctly, and that we were not complying with the newer cases from the US Supreme Court, which at that time were Snyder versus Louisiana and Miller versus Dretke. In those cases, the US Supreme Court reversed convictions and did a super thorough analysis explaining why the jury selection in those cases was in fact racially discriminatory. And so I told our court, we're not doing Batson right in Washington. What happened in this case was not right. You need to reverse this conviction and explain to everyone else how to do a proper Batson analysis. And unlike in Gregory, in St. Cali, I did not commission a new statistical study to demonstrate that we weren't doing Batson correctly and that we had a big problem with race discrimination in jury selection. Instead, I just cited existing studies and data to prove my point. So first of all, I cited that 2011 task force report on race and Washington's criminal justice system. And they did call it the criminal justice system at that time in that report. But that report concluded that racial inequities permeate Washington's criminal justice system. Now, that report did not look at jury selection specifically. It did not look at the death penalty. It did not look at every part of the criminal legal system, but it did look at many of them. And again, concluded that we had big problems with racial inequities throughout the system. But since it didn't address jury selection specifically, I had to do more. And again, you don't always have to do a multivariate regression analysis. In St. Cali, I did my own tiny little study by just doing a Westlaw search, which we all know how to do as lawyers, because it suddenly occurred to me as I was writing the Supreme Court brief in Mr. St. Cali's case, that I couldn't think of a case where a court in our state had ever reversed for improper race discrimination in jury selection. And I thought, gosh, is that right? Can that be true? So I did a search and found that it was true. We had never had a reversal for improper race discrimination in Washington, even though the issue had been raised over 40 times. So I said that in my brief and included an appendix listing all of these cases where the issue had been raised and rejected. And I said, this can't be because we have zero race discrimination in jury selection in Washington. Something else is going on. And actually the court was extremely shocked and embarrassed by that little tiny statistic. So even that, doing your own, small statistical analysis can make a difference. But the other thing I cited, and this I found just by Googling, so again, it can be very straightforward, was this wonderful, eye-opening 2010 report by the Equal Justice Initiative on race discrimination in jury selection. And what the Equal Justice Initiative did was to do a deep dive into a whole bunch of criminal trials in 8 southern states. And they pulled out the common reasons prosecutors gave for excluding potential Black jurors. And they especially highlighted the problem of people giving demeanor-based justifications for excluding Black jurors. One of the other big problems I eventually highlighted was, and this comes from our own task force report, was this problem of excluding Black jurors because they had negative experiences with the police or legal system, which is, doubly discriminatory, right? But what the Equal Justice Initiative highlighted is something that also happened in Mr. St. Callie's King County, Washington, supposedly ultra-liberal county, and that is this use of demeanor-based justification. So saying that a juror seemed hostile or didn't seem to be paying attention, or worse, a very common reason given is that a juror lacked intelligence. And that reason was also given in Mr. St. Callie's case. That reason plus the not participating, not paying attention reason, which was factually false. And I pointed that out. So this Equal Justice Initiative report was really great. I mean, it was terrible in what it found, but they did a great job presenting it. And they concluded that there was no arena of public life in which race discrimination was more widespread and tolerated than in the selection of juries. I will never forget that quote because it's so amazing, right? Here's the Equal Justice Initiative, who is very well aware that racism infects, Sal, every aspect of society, right? And they're saying, this is the area where it's worst. I mean, that was just shocking, right? So I cited that study too and said, what they're seeing happen in all of these other states also happened here in King County. And by the way, we've never had a Batson reversal, and racial inequities permeate our criminal justice system. And you need to reverse and explain how to do this right. Well, as I said, I lost the case, which was extremely upsetting. Nancy Tellner remembers this. For a long time, I was so mad I could barely speak. But some members of the court, including Justice Wiggins in his lead opinion, did at least agree with me that race discrimination remained rampant in jury selection. They just disagreed that they'd been applying Batson incorrectly and that was the reason. Instead, they said Batson itself is the problem, Batson versus Kentucky, because that standard addresses only purposeful discrimination while discrimination is often unconscious. And they use the word unconscious, even though we tend to use the word implicit more often these days. Justice Wiggins used the word unconscious, which, by the way, Thurgood Marshall also used in his Batson concurrence, which is interesting. In any event, so he said, Batson's not the problem. You lose under Batson. We need a better rule in Washington that also addresses unconscious racism in jury selection, because we do have a big problem. Now, there were also, so most of the court didn't agree with any of that. Only one other person signed on to that opinion. Justice Chambers would have reversed. He was the only one who would have. Justice Gonzalez wrote a concurring opinion in which he also agreed we had a big problem, but his solution would have been to abolish peremptory challenges altogether, which, by the way, was also what Justice Thurgood Marshall had proposed. But, trial attorneys of all stripes were opposed to that solution, and Sal can talk more about that if he wants to. So What we did instead was to try to answer Justice Wiggins's call to action to just develop a better standard in Washington, for evaluating peremptory challenges and ensuring that they were not based on race, whether you're talking about intentional discrimination, implicit bias, systemic racism, or what have you. Nancy and another ACLU attorney organized this group. As Sal mentioned, there were 6 of us on the group, including Sal and Nancy and me. And we spent the next few years drafting and revising this rule and promoting it to stakeholders and promoting it to the court. But I'll go ahead and let Sal and Nancy talk a little bit more about that process.
Sal, if you want to go ahead and weigh in on that, now that we know Lila was able to get past her bitterness and trauma of that one loss, which was a terrible loss, no doubt. Sal, what was the role that you played in this?
So before I even get there, and Lila knows I love her, and I'm sure she won't mind me telling the story, because she hates to lose. She hates when there are certain setbacks. I mean, we had a huge setback on GR 37. And I come from more of an Eastern philosophy, and I said, Lila, let me just share this with you. You know, there's an old Zen saying, when a boulder falls in the river doesn't get mad. The river just goes around the boulder. And I won't tell you Lila's response, other than the fact that I felt like my head bit off when she was giving the response. She is a fighter, and she's so passionate. I love working with her. I love working with Nancy. Just so much fun. So another good reason for becoming an ACLU cooperating attorney. I would otherwise never have met Lila or Nancy, but for my work as a cooperating attorney. And I will tell you, that has enriched my life so much. So I just want to throw that in there right now. A couple of things about GR 37 that I always like to remind people. Yes, part of it came out of what's happened was actually the ACLU started with a group of 40 of us, and it whittled down to about 6. And I remember because Steve Gonzalez was the one who wrote that dissent saying, well, we should just do away with peremptories. As Lila pointed out, that's what Justice Marshall said needed to be done, because you're always going to have racism within the system, and that's the only way to do away with that. And I remember telling Steve, look, you can do away with peremptory challenges when you pry them from my cold, dead fingers. And that is a trial attorney's response to someone saying, we're going to take away your peremptory challenges.
That's not very Zen, Sal.
Thank you, Lila. In fact, Steve's response to that, he's saying, you know, Sal, isn't that a little ironic that you're using a saying made famous by the NRA? My only reply was, no, Steve, it isn't. But it is very important for us who are doing trial work to, in fact, have peremptories. And I think we saw that going around the stakeholders throughout the state when we're going through this process. And I will say this just to remind everybody, because when I talk about jury selection, I say, you know, I've been practicing law for 35, 37 years. I have yet to select a jury. The process is one of deselection. And I want to make sure people understand that. I think it's more important in the general community. What we as trial lawyers have the authority to do is, if you will, get off people from even serving on the jury. We don't select them, we just kick them off. And what the problem is that we're seeing too many people kicked off who are people of color. There's another bigger systemic problem in that people of color aren't even coming and reporting for jury service in the first place. And that's something that has to be addressed as well. And I know there's been attempts. It's a huge problem. And people say, Sal, why don't you work on that instead of GR 37? Isn't that the bigger problem? I said, well, let's try to fix what we can. And it seemed to me that the jury selection process was the one that we could have the most impact with. And what this really does, again, is makes it harder for you to exclude a person of color. Because as Lila pointed out, you can no longer say, you know what? Juror number 8 looked like they weren't paying attention. Juror number 6 lives in the same neighborhood as the defendant. Oh, juror number 9 has a son too close to the defendant's age. I mean, Lila will tell you story after story about how ridiculous the excuses can be. But that was the problem under Batson. You, as the party challenging the use of a peremptory challenge, have to say, if Lila, in fact, used one of her peremptory challenges to exclude juror number 6, who is a person of color, I would have to say to the judge, you know what, Your Honor, Ms. Silverstein used her peremptory challenges on a discriminatory basis. She did it purposely. She purposely did that because juror number 6 is a person of color. And for me to win that challenge, the trial judge, which would be hard for me to make, because Lila's my friend, someone I practice with, okay? But she did that. She may not even be aware that that's the reason she did it, because of unconscious bias, right? But I see it. And then the judge would have to say, Mr. Mungi, you're right. Ms. Silverstein, that's the reason you did it. You used your peremptory challenge because that juror number 6 was Black. And you can imagine how hard that is for a trial judge. You can imagine how hard that is for a litigant. So when we approached this problem, we said, we got to get rid of this bar because that's really a big problem. So we kind of removed that. And what we analogized it to was, you know what, when you ask for a judge to recuse themselves, you're not saying that judge is biased. You're saying, Judge, someone looking at the situation could say that you had a bias in this situation, and therefore you should recuse yourself. So we use that same framework in developing GR 37. Let me tell you, it was a 5-year process. And I know Lila's spoken a lot of CLEs, and I have too, about the process. And it's a fun process, and if we had more time, we would tell you about it. But it's a lengthy process because everybody thinks that they can develop a better rule. And we have some very strong personalities, which I'm looking at one right now on the screen. In fact, I'm looking at 2 right now on the screen. What am I talking about? Kind of arguing what would be the best way of doing this. But we took that framework and said, if an objective observer, someone who knows about explicit, implicit institutional bias within the legal system, was looking at this from the outside, could they say, not would they, could they say that race was a factor in the use of that peremptory challenge? If it was, then you cannot use that challenge. And that is the way that I truly believe it should be. I mean, it should be very hard to get a person of color off the jury because of the history of institutional and implicit bias we have within our legal system. So that's the basic framework. It was a lot of fun. And again, a plug for being a cooperating attorney. You get to just interact with some amazing people, and it makes your career that much more rewarding. And I could go on, but I know we have limited time, Michelle, so that's going to be my little input into GR 37.
Well, I appreciate that. That's fantastic. And I also appreciate you all sharing about, as we're tackling these really challenging issues, that it's fun and rewarding to get to work with other smart people on it. I think that is a big piece of what keeps us going, right? When we do these cases that are so hard against challenges that can seem insurmountable, getting to work with people who are smart and passionate really is meaningful. I want to use that as a segue to talk about working with community. So I'm going to be turning to Dan and Nancy, but before I actually address my question to them, I do want to just remind those of you who are participating, we have about a half an hour left. As I said at the outset, your questions are very, very welcome. There was one simple question in the chat before that I answered because there was a link that was sought. But if you have questions about doing this work or how to get at it, please begin to bring those. I still have lots and lots of questions to ask. I get to talk to these folks all day long. But those of you who are watching, please start sharing your questions in the Q&A box, and I'll be watching for those. So Dan, you know, something that we have come to in this cultural moment is really a deep understanding about the importance of centering the voices of people who are directly impacted. So for a long time, and I can think about when I started my career as a legal aid attorney, you know, it was like, we know what we need to do. We know how to fix these cases. You come in, you tell us your problem, we're going to decide how to do it. You know, obviously we're going to work to your aims as a client, right? But now we're thinking a lot more about the power of the voice of people who have been impacted, the power of knowing that they actually know solutions to problems that we have not solved as lawyers for generations. And so in your situation, you've referenced that you had lots and lots of community members and family members. And so I'm curious how they influenced what you did and how you, well, let me just start with that. How did they influence what you did, and how did that feel?
Sure. I mean, I think what you're talking about is in terms of making sure that you're centering the voices of people who are affected. Our brief tried to do that just to the extent it could, in that some of the coalition members were organization. It was all various community organizations were on our brief, and many were directly involved. There were people who had been affected by police violence from the Black communities and others. But there were other organizations who weren't so much directly affected, but saw that fight as their fight too. So we were trying to, speak with the voice of all of those organizations. I think, it was actually really uplifting working with community organizations on this brief. I mean, that their voice was really the soul of the brief. As I mentioned earlier, it was important to build that kind of broad coalition to just really send the message about how much of our society was interested in this case. But I was really surprised at how excited organizations were to be a part of this. I think many community organizations were eager for constructive ways to express their outrage at Black killings, and to take this, especially if this wasn't, obviously core to their missions, to take this as an opportunity to talk internally and to their constituencies about what their organization's role should be in advancing race equity. So I think the gratitude really went both ways. I mean, we were so grateful to these organizations for signing on and making this their fight, but they expressed so much gratitude at us providing a vehicle for them to really participate in the conversation. And I think that was really uplifting to be, a part of that.
That's fantastic. I wonder if you have a sense, if one can, how things would have looked different if you hadn't really been doing that deep community engagement.
Hard to say, counterfactual, right? Like I said, I mean, that community's voice and the breadth of the coalition really was kind of the big message, in addition to the substantive points we were making. So yeah, hard to know, except that I just think it wouldn't have been as effective, right? It wouldn't, there are other amicus briefs I've worked on where, you have a very narrow group that is amicus and it works right. Like say you have a bunch of, some academic historians and, that's all you need, right? Because they're providing that perspective. But here we're providing a community perspective. And so it really did need to, involve as much as, a broad spectrum of organizations to really give it that oomph.
Well, I like what you said about those organizations really being the soul of the brief, what it was they were setting forward. Nancy, I don't know if you have anything you'd like to add, but if so, would love to hear it.
Yeah, definitely agree that that's just such a great way to say it. And it really was true. I mean, and, just emphasizing the point that the sum is greater than each part. I mean, so many of these cases that we've been talking about, it's about the team that comes together and, the input and the voices of so many different people and from unexpected quarters, and unexpected voices, but all coming together, and being able to, and that, right on the cover of the brief, literally, right? All the different groups and members of the team are right there. If the court looks at nothing else, that's what they see is that cover that lists all the groups and individuals joining the brief. I think that sends a huge message, I mean, there's no substitute for it. And I think, from reading the opinions, there's no question that it has an influence in how the cases come out, how they're considered. I just a couple other details is typically in amicus cases, we're also talking to the attorneys for the party, right? The party that we're supporting. So like Lila talked about Gregory, how that was very, very much the case. But in in this Inquest case as well. So we were talking to the attorneys for each of the families, and they had tremendous input. So, and great suggestions, especially about how it would be more the voice of the community than just, strict legal analysis kind of thing. So that was critical input. The attorney who had done the amicus brief that we joined in the trial court had, is a community activist. She had connections to community members that we wouldn't have had by ourselves. So that was another, key contributing factor. So, and again, it was every member of the team would reach out to their networks, right? And then you build, a much bigger thing than any one person or organization could do on their own. So yeah, I think that case was just a shining example of how, the court could see that, they could see the results of that, and it really made a difference.
Thanks, Nancy. I really appreciate that. So both Lila and Sal have spoken a little bit about social science evidence and about using studies. And Lila, I want to start with you because you've both commissioned studies and you have just used them in your practice. And I'm just wondering, what advice do you have? I mean, not all attorneys really know how to do that, and you've done it a lot. So what can you share with folks about when is a good time to think about bringing that sort of information in? How do you go about doing it in a really good and responsible way? Whatever suggestions you have, I think would be really helpful for the folks who are listening today.
Well, sure, Michelle. I mean, I think social science evidence is almost always helpful. And especially if you are going to be making arguments about racial bias in a particular area, which is the topic of this discussion. I mean, because you have to provide authority for your factual assertions about racial bias in the particular area, just like we have to provide authority for all of our legal assertions, right? I mean, we all think it's obvious that there's racial bias in everything, right? But that doesn't mean you can just say so. I mean, a lot of legal propositions are also obvious and well-known, right? Like everyone knows you can't walk into a house and search it. Police can't walk into a house and search it without a warrant, but you still have to cite a case, right? So similarly, if you're talking about factual information, like the level of racial bias in a particular area, you have to cite something. And, I don't want anyone to be scared off by what I said about Gregory and how intensive that work was and how many years it took, because again, that's not what you usually have to do. Most of the time, there are already studies out there, there is data out there, there are law review articles out there that you can rely on. I mean, I talked about what I did in St. Cali, and that was enough for the court to wake them up. And the same was true, by the way, when we were promoting GR 37. We still didn't commission any new study. We relied on existing studies, law review articles, case law, etc. So most of the time, you don't have to commission a new study, or even if you do, it doesn't have to be at the level of a multivariate regression analysis. For instance, the ACLU a year or two ago commissioned another study by Drs. Catherine Beckett and Heather Evans about racial disparity in life and long sentences. And that wasn't a regression analysis. It was more descriptive statistics is the term that Catherine and Heather would use. So it was a very important study, and we've all cited it quite a bit, I think. But it didn't take that long, and it's not, but it still made a big difference. So if you can't find what you need already out there, then I would recommend reaching out to a social scientist to see if they might be able to do something. And you want to reach out to them as early in your process as possible. But most of the time you will be able to find information already out there through a Westlaw search, a Google search, or as Twyla said last month, walk down to your city hall, etc. And I do also want to echo what you and Dan and Nancy just said about also bringing in community voices. I know I've talked ad nauseum about all of the statistics and studies I cited or commissioned and how important it is to show that systemic disparity and to prove that, you know, race was the factor. And it is important to demonstrate the systemic disparity, but it is so critical, as you said, to bring in the voices of the individual human beings who are affected by these systemic problems of racism. And that is something we did when promoting GR 37. And I have to admit, I got the idea from the Equal Justice Initiative because they did a phenomenal job of this. In that report I mentioned to you earlier, they did discuss all of the common reasons given for excluding Black people from juries. They discussed sort of the systemic problem and gave data about that, about the small, you know, percentages of reversals and so forth. But they also had testimonials in this report from jurors who had been excluded, you know, who talked about the indignity they felt at being excluded yet again from another aspect of civic society, right? And that was very powerful. So one of the things we did a lot of different things when promoting GR 37, like amicus briefs. Well, you know, I would write amicus briefs. Sal, who's, as you can tell, is a great speaker, would go around to all of the stakeholder groups and meet with them. Nancy did the same thing. We did a lot, but one of the things we did that I actually think may have pushed the court over the edge into wanting to adopt GR 37 was to essentially copy what the Equal Justice Initiative had done and to bring in a juror who had been excluded in a King County case to have her speak to the court at a symposium about her experience being excluded from a King County juror because of her negative experiences with the police. And I think I included a link, right, Nancy? Yeah, I did include a link to her testimonial in your materials, and you'll want to watch it. Like, she did a phenomenal job explaining it. And the justices, all, you know, they had been sitting there all day listening to very compelling presentations from people about lack of jury diversity. But when she spoke, when Ausha spoke, they all leaned in. And I don't know, and she wasn't speaking too softly. They leaned in because they cared, right? I mean, it was so powerful. So you'll want to watch that. And the point is, I agree very much with what you said about the need to couple that systemic data and social science with community voices and the voices of individuals who are affected. And our Supreme Court will listen when you do that.
That's fantastic, Lila. Thank you so much. We're starting to get a couple of questions. And so I'm going to take them a little bit out of order because one of them directly relates to what we've just been talking about in terms of the studies. And the question is, what legal or evidentiary hurdle